Yes, Mr. Setright.
My Lords, I'm very grateful for the opportunity to take stock and to take instruction. And if the Court allows, there are a relatively small number of bullet points that I will provide the Court with as a distillation of some of that which I might have said at greater length. In summary, the decision to not have a fact-finding hearing in this case was wrong and directly relevant to the issue as to whether to make an order for a summary return, in particular in face of the objections of the children that the judge focused overmuch, as I've indicated, on the allegations of physical violence in examining the allegations of domestic abuse, and without considering the enduring aspect of impact of what was alleged. There were 15 incidents which were photographed, and the judge made, we say, an inadequate examination of the detail of the allegations of coercive control, and that does relate to the approach to 12J, and the psychological abuse and allegations made by the children, which included threats to remove the children from the mother's care and threats to remove the children to the UK. The mother reported abuse post-separation, as I indicated. I give your lordships examples with references. Some abuse in 2018 when the father told that he didn't want, the female child, that he didn't want to see her and that she should stay with the mother. The reference for that is page 61, paragraph 42. But in December 2020, much later, he called the same female child something very insulting indeed, and said that she should live with the mother. That's the same page, page 61, paragraph 43. And that paragraph 45, he punished the children by not calling them over a period this year. And again, to give your lordships an example with references of the allegations the children gave to Kafka. Page 272, paragraph 16, in the report of the Kafka's officer. The female child said she was scared of the father and unable to trust and confide in him, because if she shared true feelings or made a silly mistake, or said she was scared of him, he'd become verbally abusive, indicating, we say, this is an ongoing issue. That the male child said the father hit them when they went to his house post-separation, and that they were made to do punishments when they did something wrong, doing exercises, and if they didn't know how to do this, the father would scream and shout at them. That is page 276, paragraph 27. Kafka said that the allegations were of substance and of relevance to any welfare, and I stress that, welfare determination, but Ms. Baker had assumed, when doing her written report, that there would be fact-finding in Dubai, and that it was not possible to undertake fact-finding in a summary return case. And both of those were, of course, wrong. And the references, paragraph 42 of her report, page 279, I'm mindful that there are contested allegations of domestic abuse and that the extant proceedings in Dubai has yet to address them. And at paragraph 43, page 280, the court is required to hear the children's voices and fully consider what they believe a return to Dubai would entail for them. They've experienced adversity from the demise of their family. They are reported to have witnessed domestic abuse and to have been verbally and physically abused by their father. And then finally, whilst it is, paragraph 44, whilst it is beyond the remit of these proceedings to test the various contested allegations, should such allegations be true, the children will have experienced emotional and psychological harm. So there the officer says, if they're true, they will have experienced harm from indirect and or direct exposure to domestic abuse. In the event of a summary return to Dubai, the authorities there will need to review the care arrangements that will meet their best interests. My Lord, how those submissions fit in to what my Lords already have is plain in context. My Lords, in not undertaking a more detailed inquiry into the welfare aspects, including the 12J aspects, we say, as advocated by the Supreme Court in NY, the voice of the children was therefore not effectively heard because the Kafkas officer left that open-ended in the way that I've described. This is referred to in our grounds. I haven't mentioned it, but a more direct role could have been played by the children, either in the DW inquiry, that is, my Lords, an inquiry into whether the children should give evidence or be separately represented. And it is plain that the voice of the children, highlighted by Ms. Baker, will not be heard in Dubai. Paragraph 37 of PD 12J requires the court to consider the effect of domestic abuse on children and their relationship with parents and the capacity of parents to appreciate the impact of past abuse and the potential for further abuse. That is not something which the judge within the four corners of his judgment, we say, considered, and therefore he did not look at the case within the prism of 12J. And there is, in this context, a highly articulate 10-and-a-half-year-old who's voicing vehement objections. Similarly, where the judge made an evaluation that there had been undue influence, we say that required some fact-finding. And finally, in these bullet points, we go back to NY, and I refer to some paragraphs I'd not referred to, paragraph 49 and paragraph 58 in particular. My Lords, that the some effect of those paragraphs, we say, in circumstances where the court received the evidence it did from the Kafkas officer, where there will not be a welfare inquiry or fact-finding in Dubai, where the voices of the children will not be heard, where there will be no possibility of a relocation application, and where the children are required to be submitted to unsupervised contact after a limited period of supervision. All this without a detailed investigation of the long-standing or other effects of the allegations of domestic abuse. Well, my Lord, we say that's not consistent with welfare, not consistent with 12J. My Lord,
sorry, not consistent with welfare
12
and
or
12J. Thank you.
Or H and N. I've condensed it, my Lord,
yes.
And we do stand on the grounds in full and the skeleton in full.
Thank
my
you.
Lord, I hope that is a persistent.
Yes.
No, thank you.
No.
Perfect.
Any question? No.
Thank you
very much. Yes, Mr. Devereux.
My Lords, thank you. The position of the father is that this judge carried out a comprehensive and careful review and analysis of the evidence, directed himself properly as to the law, balanced factors for and against a summary return, ultimately deciding that a summary return would serve these children's best interests. My Lords, I know that you've looked at it, but if I could take you to the order itself that followed the judgment, it's at page 45 of the appeal. From that, my Lords, one sees that the judge put in place a two-pronged level of protection, on one view, for the mother. The first was a set of undertakings given by the father that are annexed to that order and supported by a penal notice. That's Annex B at page 51. And the undertakings included on a without prejudice basis. This is undertaking 8, and with no admissions not to use or threaten violence against the mother or children, including by way of physical chastisement of the children, and not to instruct or encourage any third party to do so. In addition, of course, as we know, the return was conditional upon the settlement agreement, as so called, being integrated into the legal system of Dubai, and that in itself contained, as is clear from the page before, page 49, 50 in fact, similar provisions to protect the mother and the children. And in fact, the undertakings came about because in the course of the discussions that followed the judgment, Mr. Jarman, then counsel for the mother, indicated that he wished to have undertakings, stating that that would give extra and effective protection to the mother. In relation to the settlement agreement, the court will have seen the way in which the expert gave evidence in relation to this, and it's at page 58 of the appeal bundle. It's at paragraph 16(7), subparagraph 7 of the that particular paragraph, and you'll see there that, so page 58, paragraph 16, subparagraph 7, the judge records that the settlement agreement is binding and cannot be amended for 1 year. However, if there is a change of circumstances, then a party can apply for an amendment even before the elapse of a year. So it's an interim to medium provision, but a provision that was directed principally at ensuring that the position of the mother, because it settled matters as to what is described in the agreement as custody, and matters relating to protection of the mother and the children in relation to poor conduct of the father. The settlement agreement was directed at that principally. And the judge himself, the court will see from paragraph 26, if we go further in the judgment, page 65, was particularly struck by a number of factual aspects of the case. And perhaps the striking features are these: the children's lives, almost the entirety of their lives, save for that short period after their births, have been spent in Dubai. Their extended family on both sides, both the maternal and the paternal sides, were in Dubai. Of course, after the separation, the mother and the children were living with her own parents. The children's social milieu, their friendships, their schooling, the centre of their lives was in Dubai. And of course, the parents themselves, the Lords, had settled arrangements for the father seeing the children after the separation in 2018. And although there's a dispute as to the particular quantum, they were, on both sides, it's agreed that there was regular, unsupported, unsupervised time, unrestricted time that the father was spending with the children. And that takes place after 2018 until the mother comes to this jurisdiction in October 2021. The children, in addition, were thriving in Dubai. Additionally, this was, and perhaps we're dancing on the head of a pin, but a relatively hot pursuit. It certainly wasn't a cold pursuit. It was a pursuit that, as is the nature of these things, the mother comes over in October. There is then attempts to persuade her back in October, November, potentially December. Things solidify a little bit in January. I think there's a dispute about whether the father had agreed for the children to be put in school. He says in his witness statement that he didn't originally. But certainly by April, the father has taken steps to seek a summary return. And two final points, perhaps of factual relevance, that the proceedings, there are proceedings ongoing in Dubai, initiated by the father in January and engaged in by the mother thereafter. And of course the mother herself had facilitated time that the father was spending with the children in October and November of last year. In fact, they stayed together in a particular property, and the father saw the children. In addition, the judge had the benefit of the report of Miss Baker, which is a lengthy report, carrying out an appropriate welfare analysis, and that recommended a return. And she had the benefit, as is recorded in the judgment, from listening, recorded at paragraph 17 at 59, we don't need to go to it, but of listening to Miss Hamad's evidence. And although it's recorded that she didn't maintain such a strong recommendation, her recommendation was maintained, even in the face of the seasoned Mr. Jarman's cross-examination attempting to dismantle it.
Could I just say that it seems, looking at the expert report, going back to the settlement agreement, as if settlement agreement is a term of art in Dubai.
It is.
You know, that's where the description comes from. And so, whereas in one sense, it's not, it's an agreement which the mother has entered into, as it were, having failed in relation to her main case. By entering into it, you say that she can gain additional protections.
Yes.
In Dubai upon return.
Indeed. Displaces some of the ordinary, apparently ordinary presumptions under Dubai law, and gives her added protection so that when she gets off the plane, there is that structure in place. And it appears from other cases that your Lordship's right, that the term settlement agreement is that term of art. That's certainly...
I think it's Miss Hamadi that first brings it into the case.
Yes.
In her report.
And certainly there are other cases where she's similarly introduced that. So the judge did indeed, as we know, have that expert opinion from Miss Hamadi, who plainly he found highly persuasive and highly experienced, and she provided detailed a detailed report, and the report is in the supplemental bundle, what's described as the reduced supplemental bundle, at page 235. I don't know whether you've got access to the reduced.
So this is
the expert report of Miss Hamadi.
And what are we looking at it for?
We're looking at it because it contains within it a descriptive section on protection within Dubai. and I'm simply making the point that was also evidence that the judge had.
Which page?
It's at page 245.
Right.
And at page 243, she confirms that the courts of Dubai make decisions about children utilising a form of best interests test or approach. And at 245, she sets out, with a level of detail, as the court will see, the protective measures that are available to women in Dubai in relation to domestic abuse, both physical and emotional. And as I say, that the judge found her evidence to be clear, balanced, and very helpful. That's at page 57. We don't need to go to it. The judge himself directed himself in relation to the law, deriving it from the parties' skeleton arguments. And both parties had cited the same authorities. He particularly took as his starting point the helpful distillation of Mr. Justice Cobb in J and J, and we're going to look at that in a minute. And that, of course, distilled the authorities that Mr. Setright has rightly taken the court to or referred to, Re J and Re NY. And rather characteristically, Mr. Justice Cobb summarises in detail the relevant tenets within Re J and Re NY. And as the court has seen, the reference from Re NY includes the subparagraph which refers to Practice Direction 12J and the approach to cases where allegations of domestic abuse are raised. I want just, if I may, without going down a well-trodden path, and if the court wishes me not to go down the path or wishes to accelerate me down the path, I'm very happy to adopt either approach. But I wouldn't mind for a moment just going back to Re J, which is in the authorities bundle, the old House of Lords Re J rather than Mr. Justice Cobb's decision. It's in the authorities bundle at page 223. This, of course, was a case that involved an application for the summary return of a child to Saudi Arabia. And at first instance, Mr. Justice Hughes heard expert evidence, but doesn't appear to have heard oral evidence. Inevitably, to the extent that I need to, I rely on paragraph 12 of that judgment for the purposes of that appeal. And this will be a well-known passage which has been repeated in different forms in different authorities, and it's one well familiar to the court. If trial judges are led to believe that even if they direct themselves impeccably on the law, make findings of fact which are open to them on the evidence and careful, as this judge undoubtedly was in their evaluation and weighing of the relevant factors, that their decisions are liable to be overturned unless they reach a particular conclusion, they will come to believe that they do not in fact have any choice or discretion in the matter. One of the striking aspects of this case, the court may conclude, is the the real quality of the structure of the judgment. It's both detailed and careful. Not only does it look at the evidence in a greater detail than perhaps is necessary in a case that involves a summary determination, it also cross-references the factors that we will look at, albeit briefly, in Poole J. So, for example, the relative connections to the particular states, or the absence or not of a relocation jurisdiction. But then at the end, it goes through with care again the welfare checklist. So the structure is an impeccable structure, and one that I submit cannot properly be challenged. And that's why, I hesitate to say it, but Mr. Setright was, at least from where I was sitting, and I may be wrong, forced to seize upon an odd sentence here or an odd paragraph there. This is a high quality judgment, I submit.
Yes, I think, sorry, that one of Mr. Setright's submissions was that the judge had wrongly diminished the nature of the allegations and wrongly diminished the consequences and effects of domestic abuse and coercive and controlling behaviour.
And the response to that was exactly the court's response, which was, are you simply not able to inquire into, to any extent, into the nature and quality of the allegations? Or do you just have to accept it and say, all right, they've been made, so I must proceed immediately to a form of fact-finding?
Well, one element of it was that the judge said in paragraph 26(7) that there was no credible evidence of continuing coercive and controlling behaviour by the father, nor of physical or emotional abuse after, I think that was 2019. And Mr. Setright says that was just wrong, that there was evidence, and the judge wasn't in a position to say it wasn't credible evidence. So it's
Well, it's for him to make that out. I didn't follow. I followed the submission, but I didn't follow the evidential foundation on what the submission was made. But what's striking in my standing back for a moment is that this judge, in this judgment, goes through in detail almost all of the allegations, both made by the mother and made by the children, for example, to the Kafkas officer, or reported by one of the teachers at the school. He makes reference to the photographs, and we'll look at it in a minute. We'll look at the number of occasions he returns to assess, weigh in the balance, the allegations.
Anyhow, your current submission, if putting it maybe slightly differently, this is a judgment of 14 pages produced contemporaneously with the hearing, and that, as I expect you would put it, every sentence counts.
Yes. And its structure is impeccable, I would submit. But returning, if I may, to Poole J, if we have still got that to hand, the court, under the heading "Making the Choice" at page 235, indicates that 236, paragraph 32, that the most one can say, Baroness Hell says, in a case such as this, is the judge may find it convenient to start from the proposition that it's likely to be better for a child to return to his home country, or any disputes about his future to be decided there. The case against his doing so has to be made. And then she sets out some of the important factors, the degree of connection of the child with each country, paragraph 33, the length of time he spent in each country, paragraph 34. She then deals with welfare and different legal conceptions of welfare at paragraph 35. She deals with the differences in legal systems at paragraph 37. This is at page 237, the extent, she says, to which it is relevant that the legal system of the other country is different from our own depends upon the facts of the particular case. And she picks up that theme at paragraph 39, where she says, in a case where the choice lies between deciding the question here or deciding it in a foreign country, differences between the legal systems cannot be irrelevant, but their relevance will depend upon the facts of the individual case. And she goes on, as Mr. Setright has indicated, if there is a genuine issue between the parents as to whether it is in the best interest of the child to live in this country or elsewhere, it must be relevant, not determinative, it must be relevant whether that issue is capable of being tried in the courts of the country to which he is to be returned. And she goes on to say, the absence of a relocation jurisdiction must do more than give the judge pause, as Mr. Justice Hughes put it in this case, may, being underscored by me, may be a decisive factor. On the other hand, if it appears that the mother would not be able to make a good case for relocation, that factor might not be decisive. She then goes and says this, there are also bound to be many cases where the connection of the child and all the family with the other country is so strong that any difference between the legal systems here and there should carry little weight. And the court may well take the view that this is one of those cases. Say for that 2-month period and the period after October last year, these children and their families have been embedded, living, enjoying, thriving in Dubai. So actually, on one view, the differences in the legal systems may not carry particular weight. And just because, for example, Dubai does not have the equivalent of, say, a practice direction 12J or a process or approach that's consistent with that, doesn't mean that the courts of England and Wales are always going to be the preferred forum. I then want, if I may, to turn, whilst we're in the authorities bundle, to the decision of Mr. Justice Cobb that is integrated and followed, I would say, by Mr. Justice Poole. And we have that at page 385 of the bundle of authorities, please. This is a case from last year, a reserve judgment, hearing date on the 23rd of August 2021, judgment given on the 27th of August, by Mr. Justice Cobb, characteristically erudite and comprehensive. It involved an application under the court's inherent jurisdiction, like here, for the summary return of a child, but in that instance to Gujarat in India. And in that case, as is recited at paragraph 8, the mother had raised allegations of domestic abuse, economic abuse, physical abuse, and emotional abuse. She'd also asserted that the father had exercised extreme forms of controlling and coercive behaviour towards her. The judge, in that case, distilled the law, but before we get there, paragraph 27, he makes reference to protective measures.
Sorry, paragraph?
27, page
Thank you.
391. And he introduces that section by saying, in order to facilitate a smooth and objectively safe return for the mother and D. In India, the father is offered a range of protective measures which he is offered to secure by way of orders or undertakings in this jurisdiction. So, as with other international cases, protective measures are a currency that is being utilised to ensure either there's protection for the particular individual and or child on return, or what we describe as a soft landing. At paragraph 34, Mr. Justice Cobb distills the law, which is essentially the passage that is then relied upon by Mr. Justice Poole. Very detailed distillation of Re J at paragraph 37, and then Re NY at paragraph 38. And then at paragraph 42, he records that the father's counsel addressed the mother's allegations of domestic abuse at some length, and he deals with that. And then at paragraph 46, he records that the father's counsel had made the submission that in this regard, that even if the allegations of domestic abuse are taken at their highest, the protective measures offered by the father can be sufficient objectively to assure the mother's safety should she return to India. So it's not right if it is being said, and I'm not sure whether it is being said, that Mr. Justice Poole was, if you like, on his own, going on a frolic on his own, because the approach, what is described as the Re-E approach, but the approach by which reasonable assumptions are made as to allegations and then consideration of protective measures are laid alongside them. That approach is an approach that is being adopted by other judges of the division.
Is it an approach, or is it part of, because the thing about Re-E is it's dealing with a completely different legal context.
Yes.
And you're taking that approach in the context of Article 13b, establishing grave risk, protective factors, ameliorating or whatever the alleged nature of the grave risk. So it's a completely different structure. So it's not, you can't simply transport that approach to summary return to non-convention countries, because they depend on a welfare assessment. So how does it fit in?
Well, it fits in because it provides the court with a sufficient justification of not undertaking a lengthy and detailed finding of fact hearing. And it also fits in to the welfare checklist of protecting or meeting any risks of harm.
So what you're saying is that risk of harm is an element of the welfare assessment.
Yes.
And that, excuse me, taking the allegations, as my lord said, at face value, is a relevant consideration when deciding whether or not to have a fact-finding hearing.
Really, the question that must arise in this situation is, if not in that way, what else is the judge to do? Because it may be that I haven't yet still fully understood Mrs. Sedwright's submissions about this, but it seemed to be that the answer always came back to the fact that you are bound to have a fact-finding hearing, that you can't operate a face value system.
No.
You've got to have a fact-finding hearing, if only, for example, that something may turn up.
That seemed to be a submission at one point. And of course, one could readily see what will happen, which is what potentially could happen. I'm not saying it would happen, but with an unscrupulous respondent deploying a range of serious allegations and simply saying, Well, you're not allowed to inquire into them in any way, because if you do so, you're not actually undertaking a proper inquiry. Ergo, really what we now have to do is to have a fact-finding hearing at some months down the line. And that's going to be, it's not going to be a day hearing, likely. It's going to be a 2-day hearing, a 3-day hearing. Then is the argument that follows, well, once you have those findings determined, you need an assessment based on those findings, so you can't have any welfare assessment running in parallel.
Is it wise to depart from the sort of broad approach identified in Re J, which is that you have to decide the extent to which you need to investigate matters for the purposes of deciding whether you can make a summary return order?
Do you mean Re-NY?
Well, I mean, Re J, Re-NY. So does it complicate it by introducing the Re-E elements?
No, I don't think it does.
That's comforting.
But it's also leaving aside the question.
I'm supported by that, by what Mr. Justice Poole did, what Mr. Justice Cobb did.
Yes.
And it has a unchallengeable, I would submit.
I don't want to sort of try to see, riding two horses. Do you see what I mean? And it's definitely subsidiary. You're saying it's a subsidiary element,
yeah,
which is a justifiable factor or justifiable way of approaching
yes.
elements of the case.
I mean, it's giving, as I think Lord Justice Peter Jackson indicated, it's giving the respondent, if you like, an extra credit that they might not necessarily have. Because you're making a reasonable assumption at the highest. Whereas you
about one part of the welfare
about
equation.
risk of harm. About risk of harm.
Yes, which is, as we know, if you think of the checklist, one part of the welfare equation.
I mean, if one ran it forward, let's say the fact-finding took place and the fact-finding judge said, well, actually, all of these allegations were not made out. In fact, the mother's fabricated all of them. At that point, you're 6 months down the line, and the only thing, one of the main things, the mother say, well, look, there's this delay. So you can't send the children back to non-convention country A or B or Z.
In the civil procedure rules, there's a procedure for summary determination of a case or an issue in the case. And the test is whether the proposition in question is fanciful or not, or whether there's some other reason to try it.
Yes.
Even if it looks fanciful. I think this line of thinking that we see in Mr. Justice Cobb's decision and again in Mr. Justice Poole's decision with the Re-E label attached to it has some similarity to that in the sense that the submission that we've got in paragraph 46 here is, even if they make out every bit of this aspect of their case, the welfare assessment is still going to come down in the same direction.
Yes.
Once you look at all the rest of the factors. And there's no reason, in case management terms or for any other reason, to try the issue. Whereas Mr. Setright would say, I think, there is another reason to try the issue, which is that it can only ever be tried in this jurisdiction. It can't be tried in Dubai. That would slot into that sort of fallback.
Yes. You would say.
I'm not trying to inject the CPR into this jurisdiction. I'm just trying to get my
these
head
are
around the
helpful analogies.
conceptual process.
So, before we go from this, the thing I was trying to explore was this, that I'm not sure that Mr. Justice Cobb, for example, would admit to applying Re-E in this context. It's Mr. Justice Poole who added a label that really it might be put, might it not, on the basis that what else is a judge to do? It's common sense that in this situation, that if you are faced with contested allegations of abuse, then the various possibilities are that you simply say, well, they're not proved, we'll just forget about them, which would lead to grotesque results.
Yes.
Or you say, I'm going to decide them without a proper investigation, which would be questionable in the highest way. Namely, I'm going to make findings of fact, but not give people a chance to properly address these. I'm not sure what other alternative is left but to say, I'm going to take them at face value.
Yes. I agree, and if one goes on within Mr. Justice Cobb's judgment of paragraph 56, one sees how he resolves it and how he records it. And he says the mother raises, is at 399, 400 of the authorities fund. The mother raises serious allegations of domestic abuse which were at one time the subject of police complaint and would have been pursued, investigated further had the mother and her family wished for this. He goes on to say, although I'm not trying the issue, Mr. Khan, that's the counsel for the father, makes several effective points about the internal inconsistency of the mother's case, but this will be for the Indian court to resolve. In any event, on the mother's return to India, the risk of harm to her from this alleged abuse can, in my judgment, be appropriately mitigated, and then he sets out a combination of protective measures. That's just completing how he dealt with it.
Yes, but he went on to say that in 57, which is one of the, as my lord has just pointed out, is one of the differences.
Well, he goes on to, I have to accept that he says, well, the Indian court can deal with it, and in this case, the expert evidence is that the Dubai court can't. I accept that. And it might be just at this juncture instructive to have a look at the President's guidance for judges and magistrates, which is included at page 412 as to fact-finding hearings and domestic abuse in private law children proceedings. I accept that that's the heading, and this will perhaps be familiar to Lord Justice Peter Jackson and Lord Justice Moylan. But at paragraph 12, there's a summary of an approach when determining whether to order a fact-finding hearing. Paragraph 13, the fundamentals are relevance, purpose and proportionality. Paragraph 14, final sentence, the court only needs to determine allegations of such behaviour to the extent that it's relevant and necessary to determine issues as to the child's future welfare. Well, that's of course all consistent with practice direction 12J and H&M. And then paragraph 15 says, always consider whether the allegations at their highest go to safeguarding in general to particular circumstances that could be mitigated by supervision of contact or some other measures. If the latter and mitigations are available, why is it said that a fact-finding hearing is required? On one view, Mr. Justice Poole has adopted that approach in his analysis and assessment of whether a fact-finding hearing is going to be necessary, proportionate, have a purpose in this case.
Yes, as picking up my lord's point, that is taking this approach just as an approach, ignoring re.
Well, I don't want to get into the moment you go into re, then you're going to get advocates saying exactly what Mr. Setright says, as elegantly as he undoubtedly does say it. Well, you're transplanting Hague Convention concepts into non-convention welfare-based proceedings, and that always has red flags and lights go on and so on and so forth.
But 15 sets it out quite an
Yeah.
interesting formulation.
Yes.
And in fairness to Mr. Justice Poole, he describes himself as borrowing.
Yes. And
This wasn't. Sorry, this guidance wasn't in the. Does it make any reference to PD12J? I mean, clearly is in respect of, because it says fact-finding hearings and domestic abuse in private law children proceedings. But,
Well, it does.
Paragraph
As it says, paragraph 13 has a reference to it.
oh, 13. Yes, sorry, misread that. Thank you.
Paragraph.
Yes.
Paragraph 6.
Yeah.
Yes.
Okay. Thank you. Yes. Thank you. Yes.
I don't want necessarily, unless I'm forced to try and dig out the origins of where the borrowing from re-e phrase came from. I simply don't know. I suspect it might have been in one of the position statements, but it's probably not helpful. But it doesn't matter, because the approach I say that Mr. Justice Poole took is consistent with, for example, that summary provided by the President. If one returns then to the judgment, if I may, we can look at how the judge actually treated the allegations of domestic abuse. And my overall submission is that he treated them carefully and regarded them as being a matter of seriousness that fed into the overall welfare assessment and analysis. And just looking through the judgment at paragraph 6, a very careful summary of the mother's allegations, specific allegations that the father was conducting himself in particular ways at 6 and 7. At paragraph 8, a recording of what the children had said to Miss Baker, but contextualising it as he undoubtedly is able to, by the fact that the younger of the two children used adult language. I think the younger of the two children used the word custody, which is suggestive of direct or indirect adult influence. Paragraph 16, we obviously have a reference to the evidence of Miss Hamade, and again reference specifically to what's available in relation to domestic abuse remedies in Dubai at subparagraph 3 and 4. Paragraph 19, subparagraph 4 of NY is the reference to in a case where domestic, this is at page 62, in a case where domestic abuse is alleged, the court should consider whether in the light of practice direction 12J an inquiry should be conducted into the disputed allegations, and if so, how extensive that inquiry should be. And I simply say that he did that. When you read the totality of the judgment, he's made, he's considered whether there should be an inquiry conducted and how extensive that inquiry should be. He's come to the view that it's not necessary, it's not proportionate, and in any event, if you take the allegations at their face value, they can be met by the protective structures that are put in place. At paragraph 22, obviously, if we've looked at that, a reasonable assumption, which appears to be consistent with the approach of Mr. Justice Cobb. And I suggest that that assumption of the maximum level of risk is a position which gives, albeit I put it rather crudely, the mother the benefit of the doubt. And then finally, in the conclusion section, at paragraph 26, subparagraph 5 and 7, a detailed evaluation of the allegations and a careful scrutiny at subparagraph 8 of both all of the allegations, really, and again at subparagraph 9 on page 66. And he's dealing head on there with Mr. Jarman's submission that there are no circumstances in this case that you can order a summary return without having a full fact-finding inquiry.
Is there any difference in practice when one's considering about what you've just drawn attention to is the reasonable assumption of NY, paragraph 12? What's being referred to there is a reasonable assumption about the maximum level of risk. Is that different from, as it were, taking the allegations at face value? I mean, it's the product, isn't it, of taking the allegations at face value?
Yes.
But what you're really looking to do is, it might be said, not in a sense to make shadow findings of fact without actually engaging in a fact-finding process, properly so called, but evaluating the material that is there in order to find a product which is about the maximum level of risk that those allegations might give rise to.
There's got to be some inquiry to be able to get to your product.
Yes, but in a sense, I'm just putting to you, at the moment it seems to me that what's going on here is not, as it were, focusing on the inquiry and the individual elements of the evidence that has been given, but taking the evidence as a whole, taking the allegations at face value, except so far as they may be obviously not worthy of serious attention, but leave that aside. Then what you're looking at is the product, is what is the level of risk that these sorts of allegations give rise to.
Yes.
And so rather than thinking about saying the same thing again, but thinking about having, as it were, a dress rehearsal of a fact find in your own mind, in fact you're looking at it for a different reason, which is
yes,
to get to the risk element.
yes, I wouldn't disagree with any of that. And just completing perhaps the references in terms of the discussion about proportionality, necessity of fact-finding hearings, the court will be aware of the case of 3K, which is in the authorities bundle at page 184, and I particularly rely on, again, forgive me if I'm traversing ground that is well known, but I rely on paragraph 42. 42. And again, that's I say is consistent with the approach of Mr. Justice Poole. I don't intend to address at any length some of the other grounds. I say there's nothing in the habitual residence ground, which is ground 9. There's nothing in the voice of the children ground. I think it's suggested at some point that the children should have been separately represented. Well, that doesn't get anywhere off the ground at all. In terms of the contact and the father's and the mother's challenge to the judge's determination on contact, we've established, have we not, that it wasn't that she objected to contact per se, it was an objection to the supervision or support for contact. That's in the context of there having been no supervision or support since 2018, but also in the context that the judge considered rival written submissions on the point, and in the context that the settlement agreement gave the mother protection in relation to giving custody to her of the children, but also allowed her, if circumstances required, to amend it.
Yes, I mean, I think the submission in that respect replicates it in other respects, namely the judge was not in a position properly to make a welfare determination as to the need or
Yes.
the absence of need for supervision without undertaking.
It's in the slipstream of the principal challenge. And those are the, I think, extra points that Mr. Setbright gently toyed with, but didn't seem to pursue with unrivaled vigour. But we simply say that the judge did what he was supposed to do, and did it, if I'm permitted, from the foot soldier's point of view, rather well.
Yes. Do you have any questions?
No, thank you.
No. You have any questions? No, thank you very much. Yes, Mr. Setbright.
Brought some short points in reply, if I may. Dealing with them roughly in chronological order as made by my learned friend, there isn't a complete protection in the agreement and in the terms. I'm not sure that my learned friend would say that there was. That for breaches, the only sanction is financial, so far as one can tell. For example, and one can't invent a jurisdiction where on the expert's evidence one doesn't exist. That there was before the judge a disputed factual matrix about contact post-separation. So the happy position which is retailed by the judge in the judgment was not one that was accepted by the mother, who said that contact was ad hoc and sporadic, and produced for the judge a calendar of dates. And that wasn't a dispute which the judge formed a conclusion on, except insofar as he painted a rosy picture of post-separation life in Dubai. And of course went on to make the contact determination that he did. If my learned friend was seeking to say that the allegations, that's the domestic abuse allegations, were addressed or were addressed with sufficiency in the judgment, well, in terms of specificity, it plainly, with respect to the learned judge, isn't so. Perhaps he was doing that which my Lord Justice Peter Jackson indicated, and taking a global view, standing back, and again I'm using my words, not my Lord's, but where allegations are made and the judge is discounting their relevance, even if he doesn't go into fact-finding, a degree of close attention to those individual allegations was, we say, required of him. There were 15 allegations of physical assaults of one kind or another. There was detail of what the female child said to teachers, Kafkas. The court didn't look at the PD21J directions to see, for example, whether these constituted a pattern or cluster, or whether these were individual unrelated incidents. And of course, this is in a context whereby coercive control doesn't appear on the expert's evidence to be recognised as an actionable an actionable wrong in Dubai. And the judge simply didn't address how witnessing or experiencing the abuse may have shaped the children's views in opposing a return, which they did. He was more minded to say that this was a matter of influence. But in circumstances where he had and asserted that he was taking at its highest, whether that's under E&E, Re-E, or whether one should ignore the label, if he was taking the allegations at the highest, he should have looked at them in that context.
But your submission, as I understand in this respect, is that he didn't take them at their highest because he diminished them. He painted an unduly rosy picture of life as it was in Dubai.
If he had taken them at their highest, as arguably did the Kafkas officer, although under a misapprehension as to what the English court and the Dubai court could do, then he needed to look to see how witnessing or experiencing the abuse may have shaped the children's views and their sensibilities. And so, my lord, we do say that he fell into a significant error in this regard. I don't want to go back to old territory again, but if clarification is needed, we have not said that fact-finding is inevitably required in all those cases in which domestic abuse is raised. The caveat is subject to the provisions of 12J, because 12J doesn't say it should be fully investigated in all those cases in which it is raised. And there are the three filters, which are filters of application in the domestic jurisdiction. There's 12J itself, there's HN, and there's the President's guidance, to which my learned friend Mr. Deverex has helpfully taken the court. So we're not putting it in quite the uncompromising way that we might be styled as doing so.
So does it really amount then to you saying that the judge, if he given appropriate weight to all the considerations that this case throws up, was bound to reach the conclusion that a fact-finding hearing was necessary?
That's difficult, Lord. But he was wrong not to look at those matters in full. If he had looked at them in full, it may very well be that he would have had to resort to fact-finding, however limited. It might have been constrained within a context of what 12J required in the circumstances of the individual case, this particular case.
You're not saying that he was bound to order a fact-finding hearing, you're saying that he might have done.
My Lord, will your Lordship give me a moment?
Wait a minute, before you turn around,
Yes.
it feeds in with this. So is your submission, if we were persuaded by you to allow the appeal, that there should be a rehearing,
Yes.
or that we should mandate a fact-finding hearing? Because my Lord's question feeds into that. So,
Or decide it ourselves.
yes.
My Lord,
But you were going to ask...
I am not saying that it's realistic simply to reverse the decision and for that to be the final outcome. on the face of it, I would be suggesting that a remitted hearing was appropriate, so that the court could look, exercising, among other things, an appropriate regard to PG 12.
Why? I mean, as a way of increasing the delay, I can't think of a better mechanism. But why, if it's the case that you're simply saying that the judge didn't carry out the exercise that he should have carried out, why would that not be an exercise that we would carry out?
Because potentially at least a degree of oral evidence will be required in order to undertake that process.
You need oral evidence in order to decide whether a fact-finding hearing should be held.
One might need oral evidence, my lord. For example, from the Kafkas officer, subsequent to her making it quite clear that she had been operating under a misapprehension, and when perhaps the court would wish to explore the impact upon the children of a return in circumstances where they had, for the sake of argument, suffered this kind of abuse without an investigation, and in the context, for example, of unsupervised contact. It is entirely foreseeable that in order to make that determination, the true position would need to be explored with the Kafkas officer, by way of example.
Thank you. I think you were going to ask Ms. Kuhart something, which I distracted you from doing.
If I may.
Yes.
On that. Right. Well, my lord, our case, in answer to the question, is that if he had carried out the appropriate exercise, he would have felt bound to have undertaken some fact-finding. Because, we say, the children had suffered, on the face of it, on the allegation, abuse, and that abuse was likely to have had a substantial and possibly long-term effect upon them. And that, in all the circumstances of the case, where there can't be an exploration of these matters in Dubai, and where the court was contemplating a return with unsupervised contact with the father, required some fact-finding before that could be achieved.
And in what way is that different to a challenge to the judge's evaluative exercise? I'm not suggesting it is. It sounds very much to me as if it's exactly that.
There is an element of principle which enters into it, which is that the evaluative exercise was deficient not in quantum in some way, but in principle, because it failed to have regard to 12J, HN, President's guidance considerations, and failed to have regard to the evidence, which was of the impact in the Kafkas officer's view of exposure to these things. So, my lord, it's not simply my saying, no, I won't say anymore. It's not simply qualitative, it's principled as well.
I understand. Thank you.
So, my lords, I was going through some bullet points in reply, and I will, if I may, come back to them. We still say that adopting a RE approach in summary return cases is not easily reconcilable with what the Supreme Court said in NY, because it is a distraction from a proper consideration of welfare. I'm not going to repeat myself, I understand, of course, what my Lord Justice Peter Jackson says, which is about evaluation on the available evidence and an exercise which can be undertaken. But on Lord Justice Peter Jackson's alternatives, as put to my learned friend, one possibility was left out, which was there can be a recourse to fact-finding.
Exactly. I was looking to see what the alternatives to fact-finding
Yes,
were,
but-
and there appeared only to be one, which was to take it at its reasonable highest.
But there shouldn't be a particular fear in non-convention proceedings of fact-finding, which can, of course, be relatively limited in accordance with what the judge feels the relevant questions are. There is fact-finding in these cases going on at the moment, and it's only in the Hague Convention cases that by and large it is ruled out. So, my lords, we do say that it is a distraction and potentially misleading to transpose the RE approach. But I won't say more about that because the points have, I think, been made. My lord, and it's another way of looking at the point that I made before that. If the judge had taken the allegations at their highest, then he would have accepted that one of the reasons, or the reason for the children opposing a return, was because of their experience of the abuse. And that would need to be fed into a welfare evaluation and a contextually specific welfare allegation. Likewise, whether it was justified to order them back, overriding the objections of a primary carer who herself said she was a victim of abuse. Neither of those form part of Mr. Justice Poole's analysis, and they went to the heart of a welfare jurisdiction. My lord, the evaluation of what's been termed a maximum level of risk was something that could not be done, and this is another reflection on the same point, could not be done if the court did not make further inquiry or evince a greater appreciation of the long-term effects of exposure to abuse on both the mother and the children. And the judge was, I don't say fixated, the judge was fixated on the short term, or the restricted term of the abuse, which in terms of physical abuse ceased on or shortly after the separation. There was an alleged incident on a cruise taken after the separation. But it was not the case that there were no allegations of coercive control thereafter. There were allegations in the context of threats issued by the father very much at the time that he was taking action to seek to restore the children to Dubai. If the judge had sought to evaluate a maximum level of risk, he needed to look at long-term consequences, and he didn't do so. Likewise, financial control was a matter which was not explored in the statement beyond setting out her general coercive control case. So, my lord, we say that an evaluation, a quasi-RE evaluation, does require a full and transparent understanding and exploration, therefore, of the potential consequences in the long term of exposure, where the evidence is, as it is in this case, of actual exposure to the mother and the children. The same feeds into the question of contact, but perhaps even more directly so. My learned friend described the settlement agreement as interim to medium term, I think, but it undoubtedly set up a relatively long-term scenario for the children and for the mother, after its term has, for whatever reason, run out, then one knows what the Dubai court can and cannot do. And there's no getting away from it. The judge did determine that there was to be unsupervised contact in the circumstances of the history of domestic abuse. So, my lord, those are our observations in response. I don't think my learned friend went down the road of relocation. I don't want to, and so if I'm replying, I shouldn't be going down it myself either. But the other points in our skeleton remain.
Yes.
My lord, may I turn to those behind
Yes.
me? Anything? But of course, it may be my lords have matters to raise with me.
We don't. Thank you, Mr. Sertwright. Thank you all very much for your respective submissions. We are going to reserve our judgment. It will be distributed in draft in the usual way, and as you, counsel, and other lawyers in the court will know, that is for the purposes of only of dealing with typographical or other similar errors, not for further distribution, not for further discussion, not for further debate or distribution, if I haven't said that already. So we would hope that once you get the drafts, you'll be able to agree a draft order, but if not, we'll deal with any outstanding matters on paper. So thank you all very much.